The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Welcome to Night Court. This isn't something we do very often. We appreciate the people who have came to watch this event, and also we appreciate the litigants who, once they learned there was going to be an oral argument, and I'm not sure if you knew it was going to take away on a Monday night. So thank you very much, everyone. This evening we have one case presented for oral argument, the case of Wakonda Club versus Selective Insurance Company of America. And it's my understanding, Mr. Carney, you will be arguing for the appellant, is that correct? That's correct. Thank you. You may approach.
Good evening, Mr. Haag. My name is Jim Carney, and I am representing the Wakonda Club here in Des Moines, but I'm also here on behalf of many restaurateurs in the state of Iowa, hundreds, if not 1,000 or more. And of course, Ember's Restaurant, whose case you will hear tomorrow, or I guess take into consideration deliberating on it. This case is greatly appreciated because of the opportunity to address the court on an issue that's being considered throughout the United States, involving literally thousands of restaurants who've paid millions and millions of dollars of premiums for business interruption coverage, or what they thought would be business interruption coverage. No Supreme Court, as of today, has ruled on this type of case. There are 5 Supreme Courts that have briefs submitted and are going through the process just like we here in Iowa, including DC, Massachusetts, Oklahoma, Washington, Wisconsin.
Dive into some of the provisions of the policy, and I'd like to start with the direct physical loss or damage to property. And your colleague on the other side says, well, it's got to be physical damage. Seems to emphasize the term physical. Does physical apply to loss and damage? And if so, what impact does that have on your case?
Talking about the trigger language, and that's what we have to address in order to recover. The trigger language is direct physical loss of, or an emphasis on of and or, damage to.
Physical damage, is that your position?
That's correct. The policy was written by Selective in the disjunctive. The disjunctive meaning it can be either or, and it's not and. So you don't have to have an and in there. We know what damage to means. You damage something, you destroy something, you alter something. So the question is, what is direct physical loss of? And when you think about it, try to think of anything that constitutes a physical loss of, but doesn't also include damage to.
What if, like, a mover showed up and, put the clubhouse on, on a cart and hauled it away? That could be physical loss, but not damage.
I would think that if you took the clubhouse away, you would have both physical damage to and also a physical loss of.
Possible.
Possible, but not very likely. I mean, it's clear that when they wrote it in the disjunctive that they did not include and anticipate damage to or alteration, injury to the property when they put in physical loss of. Otherwise, it would be superfluous. The whole phrase physical loss of would disappear. It would be consumed by the damage to language.
I'm sorry, go ahead.
I don't know. Loss of property could mean total loss, and damage means partial loss. So you could interpret the phrase direct physical loss, meaning gone, or damage, meaning still there, but not functioning quite as well.
Get the word of. Of refers to like the possession of. It refers to a possessory type of situation, not.
How about the Minnesota cases, Sentinel and General Mills, I think, so where there's asbestos contamination, or you've got gasoline fumes, that would be a physical loss of the property because you wouldn't be able to use it because of a physical aspect.
Well, that's true, and we cite to you, I mean, you have pre-COVID cases and COVID cases, okay? We cite to you that long history of courts recognizing that you can have a loss of use and it is recoverable. I mean, we cite at least 20-some different cases to you where that is true. I'm not sure if I'm responding to that question.
The Sentinel case and General Mills are two examples, but there was actual physical contamination in those cases. And here you don't have any kind of physical contamination. I'm just trying to figure out what physical loss means, the physical part.
Physical, I mean, you can, obviously, we've gone through a lot of words here in trying to figure out what this policy means. And you make a great point in that the people who wrote this policy, an adhesion contract, didn't define any of those terms for us. They didn't define loss, they didn't define damage, they didn't define physical, they didn't define direct physical loss of. So that's why we're here tonight, obviously.
Switch gears a little bit, and those words, even if you are able to get beyond that hurdle of loss, I'd like to jump to that exception. The exclusion, we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism. If COVID doesn't count, help me understand, what kind of a situation would that kick in? This seems like a textbook example of a virus.
You know, that gets into the issue of we're here on a motion for summary judgment, okay? And we all know that on a motion for summary judgment, if you're resisting it, you can file exhibits and affidavits. We filed affidavits, and as near as we can tell, and I think the record's pretty clear, the court didn't give any consideration to the affidavits. I mean, it's kind of almost, I don't know, a little bizarre that we're here on a motion for summary judgment in the court.
Law, arguably. There's a question of laws, whether the contract is ambiguous or not, and how do the affidavits help us on the question of law?
They help you because the courts have recognized that you can take into consideration extrinsic evidence. There's a great case going back to 1965, the Hamilton case, that talks about extrinsic evidence and your right to consider extrinsic evidence when you're interpreting a contract. It actually was referred to in the Milligan case that no extrinsic evidence was offered, implying that it.
Recent case, 2011, Peake v. Adam, where we made clear that you do not give any weight to a party's undisclosed unilateral intent. So unless your affidavits are addressing contemporaneous negotiations to issue the policy, I don't see how the district court could have given any weight to what your affiants thought the policy covered. It's for the court to decide what the words mean within the four corners of the policy.
But there is the exception that you can consider extrinsic evidence. The court referred to that in the Milligan decision. The court referred to that in this Hamilton case that we cite you. It's a great discussion of the court's right to do that. So we think that there was an error committed in terms of the district court not considering that. And in this particular case, the affidavit was by the former insurance commissioner of Iowa, who was on duty when the circular was filed in 2006, clearly indicating that the insurance industry knew that a pandemic was out there. That's right in the appendix, pages 975 to 993, pages 475 to 481, where that is discussed. The industry knew that a pandemic could take place and it could be a disease that was transmitted. And yet they didn't consider that and putting that into an exclusion. So we're left with, the district court saying,
So you're saying that it wasn't the virus that caused your damage, but it was a pandemic that caused your damage, and therefore the exclusion doesn't kick in?
that's absolutely the fact of the matter. There's no evidence in this record. In fact, there's a denial that Wakonda had any virus problems. They didn't have any infection. There's no evidence of any kind showing that Wakonda was closed because of a virus.
Causation problem. I mean, so the exclusion uses the term caused. I'm not sure I know what caused means for sure. Does it mean proximate cause? Does it mean immediate direct cause? Does it mean but-for cause? Does it mean legal cause or proximate cause? I mean, maybe that's ambiguous. But what's your position on the causation question?
That it was not the cause. And you can look at cause, how far down the road do you want to take the causal chain before it becomes absurd, ridiculous? What we do know is that Wakonda did not close because of the virus. And more importantly, when they lifted the restrictions, the proclamation in February 5, when they lifted that, what happened? Wakonda went back into business. They opened up. And they were in business, even though the virus is still out there all over society, I mean, everywhere. People are still getting ill, people are still going to the hospital, and people are still dying of the virus. Now, if the virus was the cause of Wakonda closing, wouldn't you think that might have affected their decision, whether to...
If not this, then what? I mean, the proclamation by the governor is chock full of explanation, I think page after page of why they're doing what they're doing. It's about the virus. I mean, would there have been a proclamation entered if there wasn't a virus? Do you think this proclamation would have been entered without a virus?
Well, of course not. I mean, the proclamation, like all around the country, people were trying to react to a problem out there, a virus that was in the public. I mean, but that doesn't mean that the virus closed Wakonda.
And the exclusion says caused by or resulting from. So isn't the proclamation a result of the virus?
The proclamation came about because of the virus. The virus did not cause Wakonda to close.
You're saying it's not but-for cause, basically. I mean, I think, frankly speaking, the virus was a chain in causation. Without the virus, you wouldn't have had the governor's proclamation. If we use a but-for test for causation, you probably lose. But what evidence is there that we're supposed to use a but-for test? You're arguing for last immediate cause maybe, or direct cause, or proximate cause, or something else. I'm not exactly sure what you're arguing, but it's not but-for cause.
For any cause. Now, that's what we're saying. And you're with this quandary of how far back the causal chain you take it. Paul's
graph problem, right? I mean, it's at some point, yeah. At some point it gets, But we're, you know, we're not too far down the track. We're not 6, 7 steps removed here.
I don't want to leave that question, but I would like to mention something. There's a great deal made about physical damage, okay? This policy is like 457 pages in length, something like that, the total policy. Where in the policy does it say that you have to have physical damage or alteration to your property to recover for the direct physical loss of? Where does it say that anywhere in the policy for any loss?
Purpose does the civil authority coverage provide if, under your reading of direct physical loss, it just means loss of use?
Authority, first of all, we didn't pursue that. My time just went up. You want me to answer the question? Oh, okay. This civil authority is actually eviscerated by the law or ordinance exclusion, which is another exclusion that was raised and that we think is, you know, a proclamation, by the way, is not an ordinance and is not a law. Blacks, you can read very easily what an ordinance is and what a law is. And a proclamation is not either. So
Reading the direct physical loss coverage to just mean loss of use without physical damage, why do you need the civil authority coverage? I mean, isn't that redundant?
we're not pursuing that on the appeal. Yeah,
Policy, so each of the provisions have meaning. If you say direct physical loss just means loss of use without damage, it seems to me that that coverage is superfluous.
I honestly can't answer that question because we didn't write the policy, and we find this policy, you know, just from the beginning to end almost, every key term is not defined. These exclusions don't make sense. So, I mean, it's about the best answer I can give you. And I am over my time, unless
Crack at it.
May it please the court, counsel. My name is Doug Haag. I represent Selective Insurance Company. I just want to say at the outset that it should be known that a great majority of the cases that have been decided on the same cause of action, the same claim, the same arguments have been rejected by courts across the country, by a great majority. And particularly every court of appeal that has ruled on this cause of action, these arguments, have rejected them and have ruled in favor of the insurance companies.
Well, let's get into some cases. The Murray case from West Virginia, you're familiar with, I'm sure, but it basically has to do with falling rocks. And there was a question of whether there was coverage under a very similar triggering provision as in this policy. And the house was not damaged, the house was fine, but there was a risk. And the government authorities asked for the house to be abandoned. And that was found to be physical. Do you distinguish that case, or is it?
Case. There was not a COVID case.
But I'm not sure that the COVID cases are consistent with the prior case law, frankly. In the period of time, 1950 to 1990 or so, provisions like what you have in your policy, I won't say identical because they're not quite the same, but the notion of physical loss often covered loss of use. I think they've established loss of use here. I don't think you dispute that. The question is, as I understand your argument, whether there's direct physical loss or damage, and you say there's no direct physical loss or damage, but the Murray case cuts in a different direction. There's a case out of Minnesota involving some oats that the FDA regulated. You're probably familiar with that case, the General Mills case. And now, maybe these are outliers, and I would accept that as a possible argument, but the courts have kind of struggled with this a little bit.
I guess that's my point.
If you start at 1950, a lot of them have. If you start at 2017, you're probably closer to correct.
Hear about, isn't it?
Well, I'm interested in the general trend of the law, and I'm interested in making sure that we interpret insurance policies correctly. And I want to make sure that we land in the very best possible place here.
We plan things and then we jump around. But I want to talk about the virus exclusion for a moment. I think it's been hit right on the head. That applies here. I mean, this was a virus. We're living that virus now.
What's the causation standard that we need to use here? Is it but for, or is it something else?
Possibilities, in my view, looking at the case law. One is but for. That's what the district court did. We think that's correct, especially when you have words like resulting from. The other one is efficient proximate cause analysis that some courts have used. And basically, the efficient proximate cause is the cause that sets the other causes in a chain of activity. In other words, a cause that causes the other causes. The Seventh Circuit addressed this in particular in holding that the exclusion applied and said this, quote, "The virus set in motion an unbroken causal chain via the government orders to the purported losses and expenses." And that's what we have here.
Have maybe is concurrent causes. And you don't have an anti-concurrent clause in the contract, I don't think, or help me.
Concurrent causes apply when you have two separate independent causes. Usually one is covered and one is not. That's when you need that anti-concurrent clause. But this is one cause. We're talking about one causation here that never happens if you don't have the virus. I think it would stand most people on, would surprise people if this court were to hold that this wasn't caused by a virus.
Or cause, quite frankly. I mean, I
You don't have efficient proximate cause either, and I don't know of another standard of causation.
Virus exclusion added in response to the SARS epidemic?
I did not look at the history of the drafting because it was extrinsic, and I didn't think it needed to be considered.
Squirrel case that efficient proximate cause applies when you have a possibility of two different causes, not sort of a single chain. Here you have a single chain. So maybe it's probably more likely that but for cause should apply, or something else. I don't know.
Poise, and that is that the virus exclusion applies.
resulting in language.
Yeah, it says damage caused by or resulting from the virus.
What,
Is but for. How do you have a result without the but for? So that's what we think. I want to point out, there's a lot of semantics about this, physical damage and physical loss. The fact is there's been no physical damage. There's been no physical loss. That's admitted. The idea that partial, keep in mind, loss of use, because Wakonda kept open and they kept their kitchen open, their employees were there, they were serving meals, takeout. So a partial loss of use is not physical damage or physical loss. And this exact argument was considered by Chief Judge Jarvie in district court. The exact argument made by the same counsel in that case.
And Judge Jarvie relied on the Milligan case from our Court of Appeals. That case did not involve loss of use. They talked a lot about what direct physical loss meant, but it wasn't really in the context of loss of use. What's your best case other than Milligan from Iowa that supports that idea that physical loss requires some kind of physical alteration?
Circuit case in oral surgeons decided last July.
Relied on Milligan. I'm looking for an Iowa case that's kind of a non-COVID case that kind of talks about what direct physical loss might mean, other than Milligan.
In the context of this specific policy provision, I know of none other than Milligan. That's why everyone was citing to it, including the federal courts. So I don't know of one other than that. But Milligan, which I argued to the Court of Appeals, had the exact same language and held that it required, in order for that to apply, physical loss.
But they were just trying to decide when the time period started. And so they were looking at when the loss actually happened as opposed to when they got an estimate or a bid for it.
Argued certain things that were not physical and trying to come within that language, like getting estimates and doing repair work. And so there was an argument there that something non-physical qualified within that language.
Governor had, and let's say, assume it's not done by an ordinance or a legislation or a law. What if the governor had said, you know, we're going to need a logistics center for PPE. So I think Wakonda's pretty good location. It's near the airport. I think we'll take it over and we'll use it. Would that be a physical loss?
Probably, if there's a complete dispossession of the property, that might be a physical loss. But in that situation, other exclusions would likely apply.
What if the governor had said, you know, make sure that nobody goes into the Wakonda club, I'm going to post guards outside the club, and you can, you know, have the DPS people that usually protect me. They'll stand outside the club because it's such a great place to use. People are going to want to go there during COVID. Would that be a physical loss?
No, there has to be some tangible change or alteration or injury of some sort to the premises. Something tangible.
Profits from being deprived of use is not material?
The policy is a property policy. It provides coverage for physical injury or loss, physical damage.
Surely correct, but
Business policy. It doesn't ensure profitability, or it's not a business policy.
fair enough, but property, we say in law school, is a bunch of sticks put together. One of the sticks is free use and enjoyment. You take that stick out and your property has probably been damaged. You don't see it that way?
I don't see it. I don't see how it applies here.
What if there's
One more shot and then we'll move on, but you're emphasizing the term physical quite a bit, I think, and clearly, mental stress wouldn't be covered, you know, clearly. But loss of use where there is a material loss of income from the loss of use, is that damage to property? I think fair case can be made, the answer to that is yes. The next question then would be, does that qualify as physical loss? And some of the cases at least say yes to that.
Other angle here that we haven't talked about. You know, the rule though is we have to look at the policy as a whole, and we aren't going to interpret certain provisions that will make other parts of the policy meaningless or superfluous. The policy provides when the business income is available to the insured after a covered loss, and that the policy defines that period of time as the period of restoration. All right? So it's during that period of restoration that the business income benefits are paid, and that period of restoration ends, quote, when the property at the described premises should be repaired, rebuilt, or replaced with reasonable speed and similar quality. Now that doesn't mean loss of use. There's no repair or rebuild or replacement when all you have is loss of use. So this provision is meaningless or rendered meaningless if it's interpreted that the policy provides coverage for simply loss of use damages. This inconsistency in the policy was the focus of the Eighth Circuit in that case. And I also want to know that it was the focus of the case in Ends Up by the Sea, which one commentator has said was the most important case in COVID litigation, decided in 2021. And it's because it's a state appellate court case applying its own state law. It was a unanimous decision, and it came from a jurisdiction, California, not typically regarded as friendly to insurance people. That case is also talks about this concept of the inconsistency between the period of restoration not being applied. I see my time's up. Thank you.
Mr. Carney.
Thank you. Coming back to the cause question, I think the standard across the country has been the efficient proximate cause. We jumped into the causal question, but in my mind, I'm thinking the virus can't possibly have caused Wakonda's situation, because like the CJ fertilizer case, which was a very interesting case that really took the insurance industry to task. There was a question about whether had there been a burglary. And in that case, the Supreme Court said there's no proof of there being a burglary. And it's kind of an interesting case maybe that you will want to look at because it's got a lot of other stuff in there, including comments about extrinsic evidence, the use of extrinsic evidence being appropriate. And that's one item. The idea that we have outliers and somehow these cases that have 78 cases in the country now have courts have ruled against what the insurance industry is arguing. There are two cases we cite, the American Family case and the Mocha Transport case, that says when you have such a diversity of opinions taking place, that in and of itself tells you that there's an ambiguity. When you've got 78 judges like yourself, justices, not judges, you're justices, but the district courts, we've got judges, okay, who've ruled for the insureds. That is no small number, and those are not silly people. Yes.
How do you get around this restoration period issue if there's nothing to be repaired, rebuilt, or replaced?
be replaced, or it can be rebuilt or repaired. In this particular instance, where you're talking about loss of use, not damage to, okay? So you're over on the damage to question right now. I want to come back to the loss of use question. It's when the restrictions are lifted. So basically, February 5 would have been a restoration for the loss of use. And by the way, you ought to look at,
How is that a repair or rebuild or replace? That doesn't really seem to fit, does it?
relate to damage to property, okay? They fit in with damage to property, but come back to my initial point, loss of use. What is that if it's not damage to? It can't be damage to because it's in the disjunctive. Now, let me point out, related to your question, page 17 of our brief, in that area there, we talk about the metamorphosis of the terminology, the word loss. What does loss mean? 20 years ago when Mulligan was decided, we had one definition. You follow the metamorphosis of the term loss of use. We discuss it on pages 16, 17. And we get down to the NIAC glossary, which is very interesting. The National Association of Insurance Commissioners tell us that the glossary defines loss to include physical damage to property or bodily injury, including loss of use.
What do you make of the fact that this policy in the liability provision defines property damage to specifically address loss of use? And where in the separate coverage that we're talking about today, it does not specifically include loss of use? So do you know which part of the...
What they claim to be the exclusion?
In a separate part of the policy that, for the liability part, it actually defines property damage. So it includes, I think you are the one that pointed this out, loss of use, it's at the appendix, page 1040. Loss of use of tangible property that is not physically injured, and then it goes on to talk, so it talks about you can have loss of use if it's not actually physically damaged.
And that's what we point out. That's the point we make. Loss of use is covered.
The policy, it specifically defines property damage to include loss of use, but in this part of the policy, it does not.
It's a tangible property. They're talking about tangible property that is not physically injured. That's that's the appendix 285, I believe, that you're talking about.
My point is, in that part of the policy, it specifically defines, it has to make the point of saying the property damage includes loss of use, but in this part of the policy, it does not make that same identification.
We like you referring to that part of the policy because we believe that.
Liability coverage, it's not covering business interruption.
One final question, if I may, and that is the back on causation on the virus exclusion. The term cause might be classically ambiguous, but results from is interesting language, and it tends to, the argument was made by your opposing counsel that tends to tip it toward a but-for causation. I want to get your reaction to that.
That's why, it's not defined. They don't tell you what that means. And you go to Black's dictionary and you'll still wonder what it means. And because that is not normal language. I mean, that isn't, what you normally say or talk about. And that's why, these terms are, the exclusions are so ambiguous. You say maybe, oh, they're very, very direct. Anyone would know it. That's not true.
And I know we're beyond the time. It's just a real simple question, and maybe I'm the dumbest one in the room. You said, and I quote, because I take shorthand, the virus couldn't have caused Wakonda's situation. Tell me, what caused Wakonda's situation?
Proclamation was entered. That's, without the proclamation, of course, Wakonda would not have been closed. The question becomes, what, is that the cause of tied to the virus? No, because the virus didn't have anything to do with it.
All right, I think we got it. Thank you. We're beyond our time. Appreciate the arguments that have been presented tonight, and we appreciate everyone from the public and the legal community who made the effort to come after work hours and watch what we do normally during the day. We will resume tomorrow morning with more oral arguments, morning and afternoon, as well as Wednesday morning and afternoon as well. For tonight, court is adjourned.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.